In the matter of State of Madhya Pradesh versus Balbir Singh, Supreme Court allowed the appeal and set aside the order passed by the High Court and restored the judgment and order of conviction passed by the trial court, directing accused to surrender before trial court in 4 weeks. The court stated that circumstances in this case constitute more than a prima facie case to enable the prosecution to invoke Section 106 of the Evidence Act and shift the burden on the accused husband to explain what had actually happened on that day when his wife was killed. Quoting the judgment by V.R. Krishna Iyer, Supreme Court said this case reminds of Dharmdas Vadvani versus State of UP, wherein it was observed that the rule of benefit of reasonable doubt does not imply a frail willow bending to every whiff of hesitancy. Judges are made of sterner stuff and must take a practical view of legitimate inferences flowing from evidence, circumstantial or direct. The role of courts in such circumstances assumes greater importance, and it is expected of the courts to deal with like one on hand cases in a more realistic manner and not allow the criminals to go scot free on account of procedural technicalities, perfunctory investigation, or insignificant lacunas in the evidence, as otherwise serious crimes would go unpunished. The courts are expected to be sensitive in cases involving crime against women. This appeal was at the instance of State of Madhya Pradesh and directed against judgment and order dated 29 June 2010 passed by High Court of Madhya Pradesh at Gwalior, whereby High Court allowed the appeal filed by the respondent and acquitted him of offence under sections 302, 201 and 34 of Indian Penal Code. The deceased, namely Birindra Kumari, was married to respondent accused. In the wedlock, two sons and daughter named Rani were born. Rani at the time of the incident in 2003 was 7 years of age. On 15th July 2003, sometime during the midnight, Bhura Singh, the complainant, along with his father, the maternal cousin, brother of the deceased father, heard cries and screams of deceased coming from the house of the accused. After some time, screams of the deceased stopped. At about in the morning, they learned from the other inhabitants of the village that deceased had died during the night and that her body had been cremated. Accordingly, complainant along with his father went to Indar police station at 9 a.m. and lodged unnatural death report information under section 174 of Criminal Procedure Code in connection with the death of the deceased under suspicious circumstances. The complainant stated that on the night of the incident, at around 12 a.m., they heard cries and screams of deceased, which eventually stopped. Shortly, they saw the accused, along with family members, cremating the deceased in the field. It was further stated that when they went to the house of the accused to inquire about the incident, daughter of the deceased informed that their mother had died. Upon receiving information, inquiry was undertaken by ASI Mahendra Singh Chauhan, and it was revealed that respondent on the night of the incident had killed his wife, deceased, in the porch on the first floor by throwing her to the ground and thereafter choking her neck with his leg. Inquiry further revealed that thereafter body was cremated in night itself with help of his sister Jatan Bai. High Court, while setting aside the conviction, found the testimony of the child witness to be unreliable and tutored. The court analyzed the oral evidence and it said that it is essential to understand how the testimony of the child witness should be looked into and appreciated. The Indian Evidence Act does not prescribe any particular age as determining factor to treat a witness to be a competent one. On the contrary, section 118 of Evidence Act envisages that all persons shall be competent to testify unless the court considers that they are prevented from understanding the questions put to them, from giving rational answers to these questions because of tender years, extreme old age, disease, whether of mind, or any other cause of the same kind. A child of tender age can be allowed to testify if he has intellectual capacity to understand the questions and give rational answers thereto. In Dattu Ramrao Sakhare versus State of Maharashtra, the court held that as long as a child witness is found to be competent to depose, that is, capable of understanding the questions put to it and able to give rational answers, the testimony of such witnesses can be considered as evidence in terms of Section 118 of Evidence Act, irrespective of their tender age or absence of any oath. The only additional factor to be considered is that witness must be found to be reliable, exhibiting the demeanor of any other competent witness with no likelihood of having been tutored. It further clarified that there is no requirement or condition that evidence of a child witness must be corroborated before it can be considered, and rather, insistence of any corroboration is only a rule of prudence that would depend on the peculiar facts and circumstances of the case. In Ratan Singh Dalsukhbhai Nayak versus State of Gujarat, the court explained that although the child witnesses are considered as dangerous witnesses as they are pliable and liable to be influenced easily, shaped and molded, yet it is an accepted norm that if, after careful scrutiny, their testimony is found to inspire confidence and truthful, then there is no obstacle in accepting the evidence of such child witnesses. The court in Surya Narayan versus State of Karnataka held that evidence of a child witness who has withstood the test of cross examination should not be rejected per se if his testimony is found to be free from any infirmity. It reiterated that corroboration to the testimony of a child witness is not a rule but a measure of caution and prudence. Court further held that while assessing evidence of a child witness, court must rule out the possibility of tutoring. Even if the court finds that the child witness has been tutored, even then the statement of a child witness can be relied upon if the tutored part can be separated from the untutored part and the remaining untutored part inspire confidence. The evidence of a child witness for all purposes is deemed to be on the same footing as any other witness as long as the child is found to be competent to testify. Only precaution which court should take while assessing evidence of a child witness is that such witness must be reliable one due to susceptibility of children by their falling prey to tutoring. However, in no manner it means that the evidence of child must be rejected outrightly at the slightest of discrepancy. Rather, what is required is that the same be evaluated with great circumspection. The police statement of the witness came to be recorded after 18 days of this incident. Although the police was well aware that she was a vital witness to entire case and could guide the investigation in the right direction, yet to mechanically discard her testimony solely on the ground of delay alone was not warranted in the peculiar facts and circumstances of the case. While it is true primarily for it is for the accused to question the IO to explain the delay in recording the statement, but at the same time, trial judge should not have remained a mute spectator acting like a robot or recording machine just to deliver whatever stands pleaded by the parties. The role of a judge in dispensation of justice after ascertaining the true facts, no doubt, is a very difficult one. In pious process of unraveling truth so as to achieve ultimate goal of dispensing justice between the parties, the judge cannot keep himself unconcerned and oblivious to the various happenings taking place during the progress of trial of any case. Presiding judge cannot afford to remain a mute spectator totally oblivious to various happenings around him, more particularly concerning a particular case being tried by him. Fair trial is possible only when the court takes active interest and elicit all relevant information and material necessary so as to find out the truth for achieving the ultimate goal of dispensing justice with all fairness and impartiality to both the parties. In Munna Pandey versus State of Bihar, Supreme Court held that a presiding judge must cease to be a spectator and mere recording machine and become a participant in the trial by evincing intelligent active interest by putting questions to witnesses in order to ascertain the truth. The court also said that even if the accused had failed in putting a question in regards to delay in examination, presiding judge was duty bound to put these questions to IO in exercise of his powers under section 165 of the Evidence Act. Since in the present case no question whatsoever was put to the IO to explain the reason for delay in examination of Rani, Supreme Court should not willingly jump to discard the testimony on the ground of delay alone and ought to circumspect while scrutinizing the effect of such delay. The court in such a situation would be required to carefully see whether there is anything palpable on the face of it to indicate any malice at the end of the investigation agency in belatedly examining such witnesses. In order to obviate any confusion, Supreme Court took the opportunity to explain what is meant by tutor testimony and the test for determining or ascertaining a tutor testimony. While there has been tutoring of witnesses, the same can be possibly produce two broad effects in the testimony: improvisation and fabrication. Improvisation refers to the instances where tutored witness in question adds new details, alters facts, or provides an inconsistent version of events that were not previously stated in their initial statements, such as those given to police in their statement under 161 of CRPC. In such situations, the improvisation by way of tutoring must be eradicated only in the manner envisaged under Section 162 of CRPC, read with Section 145 of Evidence Act. The principle of law in this regard is that the witness who has improvised its testimony must be first confronted with that part of its previous statement that omits or contradicts the improvisation by bringing to its notice and give the witness an opportunity to either admit or deny the omission or contradiction. Where such witness admits such omission or contradiction, there is no further need to prove the contradiction through the IO, and its effect would be looked into while appreciating the evidence. If he denies having made that part of the statement, his attention must be drawn to the statement and must be mentioned in the deposition. By this process, the contradiction is merely brought on record but is yet to be proved. Thereafter, when the investigating officer is examined in court, his attention should be drawn to the passage marked for the purpose of contradiction. It will then be said to have been proved in the deposition of the investigating officer, who again, by referring to police statement, will depose before the witness having made that statement. The process again involves referring to the police statement and culling out that part with which the maker of the statement was intended to be contradicted. Where the allegation of tutoring witness pertains to fabrication, meaning that certain portions of both the testimony and previous statement of particular witness have been doctored or falsified. In such circumstances, twin conditions would have to be proved, namely possibility or opportunity of witness being tutored and reasonable likelihood of tutoring. The first condition, namely possibility or opportunity of the witness being tutored, can be established by demonstrating or laying down certain foundational facts that suggest the probability that the part of the testimony of the witness might have been tutored. This may be done either by showing that there was delay in recording statement of such witness, or that presence of such witness was doubtful, or by imputing any motive on the part of such witness to depose falsely, or susceptibility of such witness in falling prey to tutoring. A mere bald assertion that there is a possibility of the witness in question being tutored is not sufficient. Second condition, reasonable likelihood of tutoring, requires that the foundational facts established in first step be further proven or cogently substantiated before any portion of the witness testimony can be deemed tutored. This may be done by leading evidence to prove a strong and palpable motive to depose falsely that was imputed to the witness, or by establishing that the delay in recording the statement is not only unexplained but is indicative and suggestive of some unfair practice by investigating agency for purpose of falsely supporting the case of prosecution, or by proving that witness fell prey to tutoring and was influenced by someone else, either by cross examining such witness at length that leads to their material discrepancies or contradiction, or exposes a doubtful demeanor of such witness rife with sterile reputation and confidence lacking testimony, or through such degree of incompatibility that the version of the witness with other material on record and tending circumstances that negates their presence as unnatural. In assessing the value of the evidence of eyewitness, two principal considerations are whether, in the circumstances of the case, it is possible to believe their presence at the scene of occurrence, or in such situations as would make it possible for them to witness the facts reposed by them, and secondly, whether there is anything inherently improbable or unreliable in their evidence. In respect of both these considerations, circumstances elicited from the witnesses themselves or established by other evidence tending to improbabilize their presence to discard the veracity of their statements will have bearing upon the value which a court would attach to their evidence. Although in cases where plea of accused is mere bald assertion of tutoring, yet the evidence of prosecution witnesses has to be examined on its own merits, whether where the accused raises a definite plea or puts forward a positive case which is inconsistent with that of prosecution. The nature of such plea or cases and the probabilities in respect of it will have to be taken into account while assessing value of the prosecution evidence. Court summarized its conclusions as under: the Evidence Act does not prescribe any minimum age for a witness, and as such a child witness is competent witness and his or her evidence cannot be rejected outrightly. As per section 108 or 18 of Evidence Act, before evidence of child witness is recorded, a preliminary examination must be conducted by trial court to ascertain if child witness is capable of understanding sanctity of giving evidence and the import of questions that are being put to him. Before evidence of child witness is recorded, trial court must record its opinions and satisfaction that the child witness understands duty of speaking truth and must clearly state why he is of such opinion. Questions put to the child in course of preliminary examination and demeanor of the child and their ability to respond to questions coherently and rationally must be recorded by the trial court. Correctness of the opinion formed by trial court as to why its satisfied child witness was capable of giving evidence may be gone into by the appellate court by either scrutinizing preliminary examination conducted by a trial court or from testimony of child witnesses as recorded by trial court. Testimony of child witness who is found to be competent to depose, that is, capable of understanding the questions put to it and able to give coherent and rational answers, would be admissible in evidence. The trial court must also record demeanor of child witness during course of its deposition and cross examination, and whether the evidence of such child witness is his voluntary expression and not born out of influence of others. There is no requirement or condition that evidence of child witness must be corroborated before it can be considered. A child witness who exhibits demeanor of other competent witness and whose evidence inspires confidence can be relied upon without any need for corroboration and can form the sole basis of the conviction. If evidence of child explains relevant events of the crime without improvements or embellishments, same would not require any corroboration whatsoever. Corroboration of evidence of child witness may be insisted upon by courts as a measure of caution and prudence, where the evidence of child is found to be either tutored or riddled with material discrepancies or contradictions. Child witnesses are considered as dangerous witnesses as they are pliable and liable to be influenced easily, shaped, molded. As such, courts must rule out the possibility of tutoring. If the courts, after careful scrutiny, find there is nothing, neither any tutoring nor any attempt to use witness for ulterior purposes, then the courts must rely upon confidence inspiring testimony of such a witness. The evidence of child witness is considered tutor if the testimony is shaped or influenced at instance of someone else or is otherwise fabricated. Where there has been an tutoring of witness, same may possibly produce two effects: fabrication, and second is improvisation in testimony, whereby facts have been altered or new details are added inconsistent with the version of events not previously stated. It must be eradicated by first confronting the witness with that part of previous statement that omits or contradicts improvisation by bringing to its notice, giving the witness an opportunity to either admit or deny the omission or the contradiction. Merely because a child witness is found to be repeating certain parts of what somebody asked her to say is no reason to discard her testimony as tutored if it is found that what in substance is being deposed by child witness is something that he or she had actually witnessed. The suspicious circumstances under which deceased died, in coupled with the fact that accused had a fight with deceased 2 to 3 days before the incident, their strained relationship, and the accused frequently treating the deceased cruelly, further raise concerns and point towards involvement of the respondent accused in the alleged crime. This is corroborated by the certified copies of maintenance case and the complaint lodged by the deceased, which were exhibited and read into evidence. It is also not case of respondent accused that the deceased was suffering from any ailment, nor is there any evidence to name it to suggest the possibility of death occurring due to any health issue. It was more important, thus, for the respondent to explain in what circumstances and what manner his wife suddenly died on the fateful night of the incident. If the prosecution has established character and circumstance of acts and suggests that it was done with a particular intention, then under illustration A, it may be assumed that he had the intention unless he proves contrary. Cases are frequently coming before the courts where the husbands, due to strained marital relations and doubts as regards character, have gone to the extent of killing the wife. These crimes are generally committed in complete secrecy inside the house, and it becomes difficult for the prosecution to lead evidence. No member of the family, like in this case on board, even if he is a witness of the crime, would come forward to depose against another family member. If an offense takes place inside four wall of the house and in such circumstances where accused has opportunity to plan and commit offense at time and circumstances of its choice, it will be extremely difficult for prosecution to lead direct evidence to establish guilt of the accused. It is to resolve that such a situation that Section 106 of Evidence Act exists in the statute book. Following facts justify invocation of principle enshrined under Section 106 of the Evidence Act. Offense took place inside four walls of the house in which the respondent, the deceased, and 7-year-old daughter were living. Respondent accused has not disputed his presence at house at time of alleged incident. Failure on part of the accused to inform family members about death of their daughter and clandestine manner in which her body was cremated, more particularly when her family members were residing in the same village. By the time IO reached there, the place of incident of the body of the deceased was burned. Dubious conduct of respondent accused in fleeing away from home, leaving behind his minor daughter of 7 years all alone. Untimely death of deceased in suspicious circumstances occurring shortly after fight with the respondent 2 to 3 days before the incident, coupled with evidence of strained relationship, and the respondent accused maintained complete silence. In other words, he failed to explain any of the incriminating circumstances pointing a finger against him. The aforementioned circumstances constitute more than a prima facie case to enable the prosecution to invoke Section 106 of Evidence Act and shift the burden of accused on husband to explain what had actually happened on the day and the date when his wife died.